I'm here with Premier Las Vegas DUI defense lawyer Michael Becker. And Mike, today I want to talk about third-time DUI here in Nevada. So, if you have 2 prior convictions in the last 7 years, and you get another DUI here in Nevada, then you're looking at a third offense, right? And basically, it's a game changer. Everything gets exponentially worse on a third time. Is that right?
That is correct, because by law, a third-time DUI offense within 7 years is a felony, which is non-probationable.
So if you get this third-time felony DUI, what are you looking at?
The minimum period of time of incarceration is 1 year, up to 6 years in prison. Additional consequences are a 3-year license suspension or revocation and much higher fines on top of the time in custody.
Now, as a DUI defense lawyer, you've had a lot of success in defending clients who got charged with this third-time felony DUI. What are some of the solutions that you found to help your clients?
Well, one advantage we have from a litigation perspective on a third-time DUI is you have the right to a jury trial as opposed to a misdemeanor DUI in the state of Nevada where you only have the right to a bench trial. So we really want to look at the facts of the case on a third-time DUI to see if we have angles that we believe might have jury appeal. Obviously, the best defense would be to take the case to trial and win it and avoid the problem altogether.
So basically, as serious as third-time DUI is, the prosecution still has to prove beyond a reasonable doubt in court that our client was driving under the influence this time. And when you go in front of a jury, the prosecutor has to convince all 12 jurors unanimously of that fact. And if not, our client is entitled to a not guilty verdict.
That is correct. So to some extent, it does provide us a much greater opportunity to defend our client aggressively when we have the right to a jury trial.
Now here's a question we get a lot. Let's say we have a third-time felony DUI. We take the case to a jury trial, right? Is the jury going to be informed of the first 2 DUIs? I mean, are they going to be sort of inflamed by knowing that it's a sort of a third-time offense, or are they going to be kept from knowing about that?
Well, there is a procedure whereby you can request what's called a bifurcated trial. So you have the jury make a decision whether a DUI was committed
This time.
that time, and the jury doesn't necessarily know about the priors. Sometimes we can either admit the priors in a separate proceeding. However, if the defendant takes the stand, there's always a legal question as to whether or not the jury will hear about the priors if they take the stand to testify in their own defense.
But often it is possible to sort of exclude that from evidence initially. So when the jury decides, hey, did the guy drive under the influence this time, they don't know about times 1 and 2. And if they don't know about that, then they'd be more inclined to acquit our client this time, right?
That's correct, because there is an understanding in the law that a person should not be convicted based upon what might be deemed as their propensity to commit a crime, that each act should be assessed on its own merits, and a person shouldn't be convicted just because they seem to have a propensity for committing certain acts.
So one option, of course, take it to trial, try to get a not guilty verdict, in which case it would be utterly dismissed. But short of trial, there's some other strategies that we can employ for our client, right?
That is correct. There are some jurisdictions that have DUI courts. Clark County is one of them, and Washoe County also has one, where it's basically a last chance for DUI offenders to keep them from going to prison. And it's an intensive program. It can last anywhere from 3 years to 5 years. You still have to do, during one phase of the program, 6 months on home arrest where you wear an ankle bracelet. You're still allowed to go to work. You're still allowed to go to church and do shopping, basic essential acts. But there is an opportunity in larger counties in the state of Nevada
to avoid the 1 to 6 years in prison.
That's correct.
Now, what about negotiations? I mean, can we negotiate with the prosecutor, let's say, to reduce the charge from a third time to a second time and from a felony to a misdemeanor?
These negotiations are driven by the facts. If it's a low blood alcohol level, if there's no accident, if the speed was not extraordinarily high or the driving pattern was not extraordinarily bad, sometimes you can negotiate a reduced charge with a prosecutor. But it's very much driven by the facts of the case.
So for the person who gets arrested on a third-time DUI, who's terribly frightened, terribly upset, the message is that there really is hope. I mean, with a good DUI defense lawyer, it may be possible to take it to trial and win. It may be possible to negotiate it down to something that doesn't involve this prison time. It may be possible to get it reduced or dismissed.
That's correct, Neil. And I think it's even more important when the stakes are high that you consult with an attorney, because the consequences that you face could have a severe impact on your life, both personally and professionally.
There's a lot to lose, but with a good defense, there's a lot to gain as well.
That's correct. I'm DUI defense attorney Michael Becker with the Las Vegas Defense Group. If you've been charged with a DUI in Las Vegas or anywhere throughout the state of Nevada, call us at 702-DEFENSE and let's see what we can do to get your charges reduced or dismissed.